While we anxiously await some kind of ruling out of the Seventh Circuit Court of Appeals here in Illinois, the challenge against the state's firearms and magazine ban, we've got some filings that are being made to ultimately have the Seventh Circuit Court of Appeals evaluate what's going on over in California. But I tell you, what's going on in California with a case challenging the magazine ban, it's getting pretty contentious. But let's go ahead and take a look at the latest with the Seventh Circuit U.S. Court of Appeals. Again, they had this hearing a while back now. How many months ago was it? And we're still waiting for this case out of the Seventh Circuit. It was filed at the Seventh Circuit on the 29th of June, where they had, the lower courts in the Southern District rule a preliminary injunction, and then several courts in the Northern District of Illinois rule in favor of the state's firearms and magazine ban. So you had a mix of opinions. In the Seventh Circuit Court of Appeals, the Seventh Circuit Court of Appeals put a stay on the lower court's Southern District preliminary injunction in Illinois, and that only lasted 6 days before the stay was issued. But then you have the hearing that took place, and you've got the ongoing wait as we see what happens. And we saw where the plaintiffs had asked for the Seventh Circuit Court of Appeals to review a Hawaii federal court decision about the issue of butterfly knife bans and how those are being unconstitutionally banned. So you had that filing earlier in the month, last month. So you have now the latest being that the plaintiffs have asked for the Seventh Circuit Court of Appeals to essentially review what's going on in California, where a California judge on the 22nd of this month in Duncan v. Bonta put a preliminary injunction in place on that state's magazine ban. And when we review what's going on there, they're saying, hey, Seventh Circuit Court of Appeals, look at the Southern District of California, Duncan v. Bonta, where they said that banning magazines over certain capacities is unconstitutional. So the Illinois plaintiffs are highlighting some of the arguments that the judge in the Southern District of California made, saying that an arm needs only be regarded as a typically possessed or carried or commonly kept by citizens to be ready for use if needed. Constitutional protections afforded to weapons typically possessed by law-abiding citizens for lawful purposes, focusing on typicality and possession rather than frequency of firing. And again, that seems to highlight the idea of using a firearm as merely just possessing it, because it is a safeguard against something that could be a threat. So it goes on to say that the Duncan court pointed out that matters of historical comparison and regulations of firearms, because Bruin, the decision last year from the U.S. Supreme Court, highlighted things talking about firearm regulation and how if there's going to be some regulation, it has to be analogous with what was happening during the founding of the country. It goes on to say that plaintiffs were correct in asserting that there were no founding era categorical bans on firearms in the nation's history. And it also goes on to highlight how previous precedents showed that even the manifold early militia laws required each citizen not only to limit, not to limit the amount of ammunition they kept, but to arm himself with enough ammunition of at least 20 rounds, which of course would be more than what's allowed in a capacity magazine of only 10 rounds. So again, plaintiffs in the Seventh Circuit asking for the Seventh Circuit to look at the Southern District of California's ruling in Duncan v. Bonta, giving a preliminary injunction of the state's of California's magazine ban. But that ban is now back in place, I guess, because the preliminary injunction that the Southern District of California issued, he put a stay on it. The judge put a stay on it while it plays through the appellate process, but it was a limited stay, only 10 days. Let's now look at what's going on with the Southern District of Illinois case, where you've got the appellate court, the Ninth District Appellate Courts in California, accepting the case on the 25th of this month. And then you've got a motion to stay that Rob Bonta, the Attorney General over in California, filed on the 26th. Yesterday, you've got the appellate court here, and we'll read the docket entry. It goes on that they filed an order, and you've got the en banc panel has elected to accept this case as a comeback. So the Ninth Circuit is going to do this as an entire panel, not a 3-judge panel. Attorney General Bonta has moved to stay the district court's permanent injunction, except to the extent the California Penal Code prohibits possession of large-capacity magazines that were lawfully acquired and possessed prior to the district court's judgment. This emergency motion seeks relief on or before October 2nd, it's just around the corner, when the district court's stay on the injunction expires. In the event the court cannot resolve the motion by October 2nd, appellant seeks a temporary administrative stay. The motion for a temporary administrative stay is granted. So, while the Southern District Court in California said a preliminary injunction gonna kick in 10 days, the appellate court in California, the Ninth Circuit, is extending that stay. So they're granting Bonta's motion to extend that stay. The injunction issued by the district court is stayed through October 10th. The stay does not apply to the district court's ordering enjoining a section of the law for large-capacity magazines that were lawfully acquired before the district court's order. Appellees are directed to file responses that by Tuesday, October 3rd, so we'll be watching that. But if you look at this, of course, this is a decision by the Ninth Circuit Court of Appeals to go en banc, and then you take a look at the filing here. And you've got, the description, the motion for temporary administrative stays granted, the various judges that agreed to this listed here. But you have those who dissented. And in the dissent, you've got one of the judges essentially saying that for over a decade, our court has improperly interest balanced our way out of the Second Amendment. Goes on to say that with clear direction from the Supreme Court, you might think that our courts, the Ninth Circuit Court of Appeals, would return to regular order and handle this Second Amendment case like all others before our court. And in the normal course, emergency motions would be handled by a 3-judge panel, but not here. Because this is a Second Amendment case, we now take the unprecedented step of taking an emergency motion as an en banc panel in the first instance. While our rules may leave room for such unusual step, discretion and wisdom counsel against it. Indeed, to my knowledge, no en banc panel of the court has ever handled an emergency administrative stay motion as an initial manner. As the majority cites no precedent otherwise, so I'm left wondering why we rush to do something so unorthodox. And again, this is the one of the judges in the Ninth Circuit Court of Appeals dissenting from the en banc decision to hear the emergency case before the Ninth Circuit on the California magazine ban. I thus respectfully dissent from the grants of administrative stay. Such a decision would be left to the sound judgment of a 3-judge panel, and somebody else dissenting in the Ninth Circuit sharing that judge's concerns about the irregularities created by this en banc panel's all too predictable haste to again rule against the Second Amendment. Apparently, even summary reversal by the Supreme Court has not tempered the majority's zeal to grab this case as a comeback, the judge says. Stay the district's court decision and make sure that they, not the original 3-judge panel, get to decide the emergency motion and ultimately the eventual merits question in favor of the government. I think that it's clear, this judge says, enough to everyone that a majority of this en banc panel will relinquish control of this case only when it's pried from its cold, dead fingers. And I think it's clear enough to everyone why. So again, the judges here dissenting from the Ninth Circuit Court of Appeals deciding to issue an emergency stay and to take the case not as a 3-judge panel, but en banc, which means the entire Ninth Circuit Court of Appeals in California. So while the plaintiffs in Illinois in the gun and magazine ban look to have the Seventh Circuit Court of Appeals in Illinois review not just the Hawaii case, but also the California case on magazine bans, you've got some tension in the court system in the Ninth Circuit Court of Appeals that represents California and how that's going to play out, let alone the decision that recently came out of, I believe, Washington State, or was it Oregon? I'll have to check my notes on that. But yeah, it's obviously There's a lot of tension in the judiciary, but I think a big question needs to be the integrity of the judiciary and for people's ability to best trust the judiciary as that form of government providing a proper check on executive authority, the ability for the legislature to craft laws, taking away rights and whatnot. But let's just read here finally to wrap this up. While rules may leave room for such an unusual step, discretion. One of the dissenting judges in the Ninth Circuit says, discretion and wisdom counsel against it. Indeed, to my knowledge, no en banc panel in this court's ever handled an emergency administrative stay as an initial matter, and the majority cites no precedent otherwise. So I'm left wondering why we're doing this unorthodox. And also another judge saying, I think it's clear enough to everyone that the majority of this en banc panel will relinquish control of this case only when it's pried from its cold, dead fingers. This is a phenomenon that long has been recognized in abortion cases, sometimes called abortion distortion, that describes courts' willingness to jettison procedural norms or other normal rules as decision-making when a case concerns abortion. As the Supreme Court recently observed in Dobbs, abortion cases have led to a distortion in legal doctrine ranging from severability to First Amendment doctrine. And Justice Thomas has likewise described the troubling tendency to bend the rules when any efforts to limit abortion or even speak in opposition to abortion is at issue. So clearly, cases involving the Second Amendment, this judge says, is in our circuit have unfortunately suffered from a like phenomenon. And just as we should no longer distort our rules in abortion cases, we should no longer apply different rules to different constitutional rights. We should not give Second Amendment cases special treatment. But the current irregularities highlighted by Judge Batami's dissent are not the only way this case continues to demonstrate our court's enduring bellicosity toward the Second Amendment. That's a new word. I'll have to look that up. The irregularities in this case ran much deeper indeed, all the way back to when the case was first called en banc, and it goes on from there. So clearly, again, tensions in the Ninth Circuit Court of Appeals, while the Caleb Barnett et al. Plaintiffs in Illinois asking for the Seventh Circuit Court of Appeals to review the lower court's decision there. Where this goes from here, we'll just keep tracking.